to this particular startup. How this particular startup has to be step ahead towards innovative journey of existing production. त्यासाठी आपण थोडंसं हे करूया. Major of the people are bit known about it, but we'll see, sir. Yes, we will take around 35 minutes for the session, and for 10 minutes for Q&A.
Sure.
If we could go around 5 to 10 minutes extra, it might be. Yeah.
Okay.
Yeah.
You're able to see the screen?
Yes, we can see.
Yes, sir.
Yes, sir.
Sir.
बाकीचे काही रिमूव्ह होणार आहेत ना त्यामुळे काही ते Okay, so we will start the session, sir. Prior to go ahead, I will like to, sorry. Okay, almost all startups has joined, sir. Prior to go ahead, I'll just introduce about our today's speaker, Mr. Ashutosh Prachan. Today, Ashutosh sir is having the around 10 plus years of experience into the intellectual property and towards filing and executing many intellectual property in many sectors. More of them are in biotechnology and the agriculture sector. So currently, Ashutosh sir is a patent agent, technology transfer professional, trees practitioner, having 10 plus year of experience and closely working with the SMEs, individuals, and the startups who are working towards the innovative areas. There is the Ashutosh sir is helping out, and also currently he's running in a Naughty IP firm in Pune. So he's also interacting with our scientists at ICAR-CIRCOT towards helping and hand-holding to file of IP in different areas like biopharmaceutical, medical devices, biotechnology, material sciences, mechanical and electronics domains. So he lies in technology transfer, IP commercialization, and tech and IP valuation as well. So recently, Ashutosh sir has also started, giving sessions towards highlighting the problems from 0 to 1 and how do we address startups towards getting funding ready. So this journey is very bit, the sir journey is very, helping towards our startups. So today we will have a session with our startups. So prior to go ahead, I will also give the brief about our current cohort to Ashutosh sir. Ashutosh sir, we are currently incubating and training 23 startups in cohort 10. 2 of them are into the Arambh program, which is up to 4 lakh rupees of funding, and 5 of startup are into Uday program, who are where we are giving funding up to 5 lakh rupees, and remaining 16 startups are into Ankur program, which is funding initiative of up to 25 lakh rupees. So this is the brief. Ashutosh sir, if I miss anything while explaining your profile, so just add on. Yes, we can continue with the topic with introduction to intellectual property rights, scale your startup by innovative approach. Yes, sir, over to you.
Thank you, Uday, for that introduction. And very much delighted once again to be on this platform to interact with the innovative startups which are getting supported by CIRCOT R-ABI. It's always a great to interact with all of the startups that are incubated there, and the kind of commercialization activity that has been taken care by CIRCOT R-ABI is also something which is commendable. Naturally, this is a very crucial aspect in any business, along with other functions that are there in any given business. IP rights, if you're running something which is a very technology based kind of a startup, you need to pay attention to what kind of IPs that you are generating and what are the different tools by with which you can protect your intellectual property. So want to highlight two main pointers here. One is that intellectual property, and the other is intellectual property rights. So intellectual property is generally something which you have invented or created, okay, and that sits in your head. Unless you file it with the proper means, meaning which, if you're filing patents, if you're filing copyrights, if you're filing trademarks, if you're filing industrial designs, it gets converted into rights, because now you are asking for the protection rights on top of what you have created. So long as you have not filed anything, it is just intellectual property. The moment you file something, it becomes intellectual property rights. And then there are different tools by which you can leverage and monetize the intellectual property that you have created. This is a very promising tool used by many companies, many startups in all of the sectors and domains, essentially to help boost their investor confidence. That is the primary focus of, or should be the primary focus of filing IP. The second is that you are creating a good moat around your technology and also products by protecting it with the right type of IP tools. And thirdly, it gives you recognition in the fraternity. And it also, as you might have been experiencing, it's a good tool for raising the funds from different government schemes as well as from private investors as well. So let's dive into the session. And here I want to take an opportunity to also discuss a little bit about the difference between invention versus innovation. Uh, Largely, these two things are looked at from a single lens, but these are two different things having a very thin line difference into it. So something which is created newly, or you found out a way of doing something differently or creatively, is innovation. Unless you put that innovation into legal context, meaning which you are qualifying them into something called as intellectual property rights, it converts into invention. So I want this session to be a little interactive, and then my question goes to the audience, and I want to take a quick feedback as to what exactly in this you feel is invention, and what exactly is innovation. So I can just you can just open the mic and then tell me how do you want to classify inventions and innovations in the pictures that I've shown. Quickly, we don't have much of time, so anybody. I can see House of Piranesi.
I
I
yes, I was thinking if the stone wheel would actually be the innovation. Um,
Okay.
and if now that let's say if that was MRF tires, the last picture that you have,
Mm-hmm.
they have actually filed the intellectual property, then that becomes invention for them.
Right. Right.
According
So
to me,
any.
invention is a new thing which we are
Mm,
coming with, and
mhm.
innovation is on that new thing we are developing a technology that is innovation.
Uh, Okay. What else? Any one more answer, and then we can move ahead.
Invention is a new creation, while
Mm-hmm.
innovation is something improvement into the existing. That is, if stone wheels from stone wheel to that wooden wheel, they
Mm-hmm.
have that create a new things. That means there are the arrays are there. So that is a new creation. And
Mm-hmm.
while that is MRF or something that wheel, this is
Mm-hmm.
a improvement of this. So it can
Right.
move fastly and everything. Right.
Correct. Correct. So you you all are correct. But what we need to understand here is that the stone wheel was created and it was very new. I mean, it was not existing only. So it was an invention, something that never existed. Okay. And if you're creating something like that, it naturally is an invention. Okay. So 15 years back, we did not know about nanotechnology. So you can say that it's an invention. Now, when you develop application based on nanotechnology, you are innovating onto something which is a platform technology, and then you are constantly improving upon. So the stone wheel is invention. Now, from IP point of view, the wooden wheel also is an invention. Okay, because it has taken a shape. It has taken a form factor. It has taken care of the problems that were associated with the stone wheel. Okay, it has taken care of some sort of longevity and less variability, and all of those things has been taken care in the wooden wheel. Now compare that to the modern wheel that is there on the extreme right side. That also is invention only. But when we say about, when we talk about innovation in general, somebody was saying something. Okay. So when we have to generally take into account what exactly happened here, which was innovation, is how some customer feedback. Naturally, the stone wheel was used by somebody, and then they found out some problems, and then they solved those problems. So essentially, the kind of methods you use to solve the problems in a unique way is innovation. And then if you are adding some technical features onto it, it is an invention. Okay. So these are three primary criteria for, when you want to categorize your innovation into invention is does it have novelty? Does it have industrial application? And does it have technical improvement? So if these three criteria are getting a good tick mark and it is going to flash in very bright green color, you can consider that as invention. Same goes here. So what according to you is invention and what is innovation? I've flashed a next set of images. Uh, Somebody who has answered earlier might want to give other people a chance. What is
First one
this?
is a,
Yes, please go ahead.
yes, sir. Is a first wire one is a invention, and second and third one is a innovation.
Why do you feel so?
Because second and third both product are made with the first one.
Correct. So, but the application remains the same. It is used for filtration only. In the second product, you are filtering liquid materials, and in the third one, you can probably use it to filter air or anything which is unwanted to enter into your rooms and houses, right? But it is made from the steel wire only. So it also depends on whether you call it as innovation or invention, is on the field of application, where exactly you're wanting to use it. And with the moment you find out that, oh, this steel wire, if I can make it into a medical grade steel, and I can use it into stent is a new invention, correct? So even though the basic component remains the same, your innovation activity has to be streamlined to generate a lot of intellectual property, meaning which it has to get converted into inventions. Now, you all must have been going through a lot of training sessions, and what I wanted to touch upon very briefly is a path from invention to product in 6 aspects of taking an invention to a product kind of a phase. So first is naturally the technology development. The second is securing your intellectual property. What belongs to you should be owned by you. Then probably you will be looking into some manufacturing process development of the products that you're working on. You will have to work on the financials, business development side of it, and the company's overall management and operations. So whenever you are thinking of creating a product from a conceptualization stage or an idea stage, you will have to follow these 6 pointers in a nutshell. And of course, there has to be a systematic evaluation of the ideas that you are coming up with, and then you'll have to follow some systematic innovation methods, then design thinking, and some techniques such as Camper to generate a lot of ideas as well as to select which ideas you should use to take ahead and then implement and then convert it into a sustainable and scalable kind of a business model. So one more example that I want to give here is light bulb. Everybody is aware of this. Who was the inventor of the light bulb?
Thomas Edison.
Thomas Alva Edison.
Edison.
Any more answers?
Thomas Alva Edison.
We are coming to a very crucial point here. Thomas Alva Edison was patent holder. He was not the inventor. The patents were in his name. The inventors were the staff that he had recruited. They did all the experimentation. They tried it with different materials, and somehow somebody found out that it works with tungsten well. Okay. So he was not the person who did all the experimentation. He funded the research. Okay. And he owned income as a compensation of that, he owned patents on the light bulb. Okay. So we are coming to a crucial juncture here, which means that we need to understand the difference between an inventor and an applicant, or somebody who owns the patents and somebody who works on the patents, or who reduces the ideas to its fullest extent. The people who work on the innovative ideas and reduce it to practice are somebody who can be categorized as inventors. Okay. And the applicants as well. So in a company, typically what we recommend is that if your company is developing a good portfolio of IP, the IP should be in the name of the company, because the applicant or the ownership rights has to be with the company, because that is something which is going to add value in the company, as well as it is going to showcase the company that it is an innovative company, having filed so many patents and designs and trademarks and copyright and so on and so forth. It also helps in developing the investor confidence. They also look at IP from a very strategic point of view, that their money is invested in a company which is very well protected and is trying to create a monopoly in the given space. So all of the IP is basically for creating a monopoly around what you have created or invented. And when I say monopoly, it has to be commercialized. It has to be, monetarily benefiting you to a larger extent. So gone are the days when people are, wanting to file one patent per product. It has to be, a cumulative set of patents, trademarks, copyrights, and designs put all together, and selecting based on what kind of products you're developing. You have to select the type of IPs very strategically, and that's how you should, go ahead when it comes to intellectual property protection. So these are different types of light bulbs. We are normally aware of there is a light bulb, and then once you put on the switch and the bulb operates. But there are these many products that are available. These are light bulbs only. But then what I want to show with this type of a slide is how technology transition happens. So there's a basic light bulb, which is a regular with a switch. You turn it on and turn it off manually. Then comes the automated one, wherein it is a timer based light. It turns on and off at fixed times, no external input required. So there is some level of innovation happening on top of this. Then there comes smart bulb, like Philips Hue, which is basically controlled with an app or a voice assistant. It reacts to your gestures and commands and so on and so forth. You clap twice, it turns on. You clap once, it goes off, right? Then there comes an intelligent bulb, which learns your habits as you move in the house, as you're occupying space in that particular area, at what time you are coming in that room. It makes sure that at 7 o'clock, if you're entering in the house on a majority of your month, then it will track that kind of an activity, and it will turn on at 7 o'clock. Then comes the cognitive based bulbs. So a light system that understand the context. So if you're watching a TV versus you are reading versus you are, just having a dinner, based on that, it will adjust the lighting. Then comes the adaptive. So it learns from the feedback, and then it gives, it dim it manually a few times after 10 p.m. If you are doing it, it starts doing it on its own after a certain period in time. So this is transitioning towards a smarter kind of a bulb ecosystem. Then comes autonomous. The system independently manages lighting based on your presence, time, weather, and your past patterns. So all I want to say here is, for a product to improvise, you need to anticipate all the features that you can incorporate in that product in the coming years, right? But the IP needs to be protected from day one, like from the basic till you should be able to imagine what is the sentient mode of my product right now. What is the adaptive mode of my product right now? What is the autonomous mode of my product right now? Okay. And once you have that ideation and imagination power, only then you will be able to think about what are the different modifications that I can do, what are the different innovations that I can do on my base product, and which will naturally be useful for the longevity of the business, as well as somebody who is looking at your company from a different standpoint, as a customer or as an investor or as a someone who is the part of the company, your employees and so on and so forth. They will look at your company as something which is a very unique and innovative company. Before we go into the types of intellectual property, this is the Instagram page that I am running. It talks about innovation, creativity, and entrepreneurship. So if you guys are interested, you can scan this code and then follow, and you can get updates about all of the things that are happening in the innovation and startup ecosystem. So this is the kind of mode that I'm talking about exactly. So there are different types of modes. The mode can be created with the technology that you're developing, the brand that you're developing, the data that you are creating while you are running your company, and the network that you have along with the company. So this is one of the posts that I had created a few weeks back. So you might want to follow if you're interested. Moving on to the types of intellectual property rights. There are these many different types of intellectual property rights that exist, which enables you the protection on top of what you have developed or what you have created. And depending on what you have developed or what you have created, the nature of the IP or the type of IP needs to be selected. So there are patents, there are copyrights, there are designs, there are trademarks, there are trade secret, and there are plant varieties as well. Now, these are the outcome of the innovation activity that you did. Okay. And it has to be a byproduct. IP always has to be a byproduct of the innovation that you're doing. Okay. So once you do innovation, all of these things will naturally occur. Okay. So let's look at it one by one. Copyright, simply put, is a right given to the law to the creators of literary, dramatic, musical, and artistic works, and producers of cinematographic films and sound recordings. The primary criteria is that it should be original and it should be fixed in a tangible form or a tangible medium from which you can later on you can retrieve all that content that you have thought, maybe you have imagined. Okay. And this is where I want to go back to the slide where I was talking about it is always and always it's an IP, intellectual property, unless you have brought it down on a piece of paper and you have filed for a particular type of protection. Only then it gets converted into intellectual property rights. Or else, like right now also, when I'm presenting or when I made this presentation, everything was in my head. So I wanted to weave a story and then create a presentation for you guys so that you can ponder upon it, think about what different types of IP you are creating right now, what should be protected, who to approach when you want to file it. Okay. But then when I have now compiled it and I have put it on a presentation, that's where I have created a copyright. Okay. So this very presentation is a subject matter of a copyright application. Now, the very interesting thing with the copyright is that it comes into existence as soon as it is created. So you don't have to have a formal registration of copyright but then it is mandatorily required, because tomorrow in the let's say in the court of law, if you want to defend yourself against any infringement, you have to have a copyright certificate with you. How many of you have seen the movie for which I have shared a picture here?
I think everyone.
Everybody? I think everyone, right? So the Hindi movie collection was 478.3 crores, and Dharma Production, who bought the rights in the Hindi movie, they own 10% of the. So they just said that I want 10% in the entire deal. Okay, this is the value at which the copyright makes. This is the value of the copyright that is there in the movie sector. Okay. Likewise, you may find copyrights in the music recordings also. All the songs that you hear, all the jingles that you hear, all the radio advertisement that you hear are all subject matter for the copyright. Okay. Now, interestingly, when you hear a music on a radio channel, may it be Prasar Bharati or any other radio channel, Radio Mirchi, and so on and so forth, every time a music is played, every time a song is played, the music company gets royalty for every time the song is played. Okay, so that's the beauty of copyright, and it's a very interesting tool, especially in the field of entertainment, to monetize what you have created. Next comes very important, and I think this is the first and foremost IP that you should protect as a business, is something called as trademark. That now trademarks are distinctive signs used to differentiate between identical or similar goods and services offered by different producers or service providers. So it basically, what it does is it creates a differentiator. So people are able to recognize you based on the kind of color combination that you have used, based on the kind of artistic manner in which you have created your logos, and so on and so forth. So tomorrow, if I want to create a brand like Rico, okay, because Vico is established, I want to name my brand as Rico. I am essentially creating a confusion amongst the people who are already accustomed to use Vico. Okay, so your brand or your trademark essentially has to be a differentiating factor, and it should differentiate your businesses from somebody who is already existing in that particular segment. So trademark can be a combination of words, letters, numerals, or it could be a drawing, it could be a symbol, it could be audible side, it could be even a fragrance, it could be colors used as distinguishing features. Okay, so everybody is familiar with Mr. Okay, you're in your own hometowns, you know a particular spot. If that kind of a fragrance comes, you say that, "Are hi ती मिसळ है." किंवा, if a particular smell comes, you say that, "Oh, it is that hotel from which this is that hotel nearby." असं आपण म्हणतो, बरोबर आहे. So fragrances is also something which is very unique, and it's a trademark of that particular brand. Okay, and naturally colors used as distinguishing features. So let's say if I am giving an example of a telecom company with a red color logo, which company comes to your mind?
Vodafone.
Airtel.
Airtel, Vodafone, right? Correct. If I tell you a telecom company which uses yellow as color,
Idea.
right?
McDonald's.
So perfectly. And which is the company which makes pizza and has a color combination of blue and red,
Domino's.
Domino's.
right? So you are associating. So even if you enter into their outlet, you will see the similar kind of colors being used. So that's called a trade dress. Okay, there is a trademark and there is a trade dress also, which means that I will constantly keep my branding and communication in the exact same manner as that of my trademark. So trademarks beauty doesn't only stop at that you created a logo and you created a logo with a different color combination and put it on. Okay, it has to be distinctive. It has to differentiate between identical or similar goods. If you keep on using, so let's say tomorrow one of you want to create a very organically developed pizza brand, okay? You will have to stay away from these color combinations, okay? Or else what will happen? Domino's will come and say that, hey, you're copying my style, you're copying my branding and communication protocols. They'll come to you, sue you. Okay, so it has to be a very distinctive kind of a logo and all the trade dresses that you are going to provide. The next type of IP is an industrial design. So as the name only suggests, it protects the external outlook of a product that is improved aesthetically, ergonomically, and from the usability point of view. What do you mean by this? So when I create a product, I have to make sure that it is looking attractive so that its market value increases. So people come and buy that product from you. And that's the reason why you want to have a particular design of your product. So you want people to buy that product. That's why you are improving the look of it aesthetically. You want to make sure that people are able to use it very conveniently. So you are improving it from usability point of view also, and naturally from ergonomic side, because you want to develop a product which can fit into a particular given customer segment as well, or in a particular given area or jurisdiction or a particular territory, right? Now, everything that has to do with the external outlook, such as shape of goods, or it could be ornamental design, it could be a configuration, it could be a pattern, it could be a combination of lines and colors and so on and so forth. Everything accounts for industrial design. Okay, so you can see that people are wearing white color shirts, but then there will be an inherent pattern of the shirt. The weaving pattern will be different. The quality of fabric will be different. So the design will be different. Okay, so every apparel that you are making, okay, if it has a different design, it is eligible for an industrial design. Similarly, any devices that you are making, even your, many of you are into food businesses. So the kind of packaging that you are having, if your box is having a very unique shape, which allows the users to use it very conveniently. Okay. How many of you have seen the Chayos packaging? Has anybody seen Chayos packaging when they send a parcel to you?
Yes,
It's a very
yes,
peculiar
yes.
packaging, right?
Yes,
You can easily pour the tea into your cups,
yes,
right?
true.
That is something where they have aesthetically also and ergonomically and from usability point of view designed their packaging in a way that it benefits whom at the end of the day? The customer. Okay, so if you are doing these type of iterations and changes in the designs, you're naturally eligible for filing an industrial design application. Trade secret is also one of the very prominent IP that has played a huge role in the companies and organizations that I have put forth. So it is basically, as the name also suggests, it's a secret, and it's a type of information including formulas, devices, patterns, financial information, client list, unannounced products, business plans, that an enterprise feels has some value into it. Okay. And also it offers a competitive edge over your competitors. That's when it can be counted as a trade secret. Okay. So all those things that you are doing for distribution of the products, identifying your consumer profiles, your advertising strategies. Maybe you want to create an advertising strategy that you will only and only put your products at public areas, meaning which you will place it in railway stations, bus stands, rickshaw stops, and all of those things. That is your strategy, right? And that can be kept as a trade secret. It could be your list of suppliers because you want a particular quality of the raw material that you are procuring. So that can be a trade secret. Your manufacturing processes. There could be some of the things that adds and gives you a competitive edge over the others, and it is very well hidden in the manufacturing process. So you may want to keep it as a trade secret. Now, these are the companies who have been successfully been able to do it, and they are doing it very prominently as the business is growing. KFC has their the spice mix as a trade secret. Coca-Cola also has their recipe as a trade secret. Listerine doesn't disclose their formulations at any given point in time. I want you to tell what is Google has kept secret from us. Any ideas? Think. Any ideas as what is that Google has kept as a trade secret?
Initial codes, maybe.
You're close, but not there.
Algorithm.
Sorry?
Algorithm
Algorithm for?
for like the search engines and everything.
Yeah,
How
so
to
yeah, exactly. So when you say algorithm, whenever you do a Google search and you kind of see the very promising results and the very appropriate and relevant results on your first few search results, that is something which Google has kept as a trade secret. They don't tell it to anyone. What and all algorithm runs, which captures all the data of your location, of the businesses that are around you, and things like that. It just shows up. Okay, so nobody knows what that code is, right? So now you will say that why you have to, if you want to keep it as a secret, just keep it as a secret. No, why do you have to count it under intellectual property? Arriving at something like this involves heavy discussions, brainstorming on many ideas put together. And that's how you will be able to categorize what needs to be kept as a trade secret, what should be filed as a patent, what should be filed as a trademark, what should be filed as a copyright, and what is something that is know-how. Okay. Even though know-how is not listed in under any of the intellectual property rights, it's a form of intellectual property. So you have to be able to categorize essentially what is something that is IP-able subject matter, meaning which you can file for patents and copyrights and trademarks and so on and so forth. What is something that you will keep as a know-how, and what is something that is trade secret in your business, right? Once you get a hang of all of these things, your IP strategies start to evolve as an organization, as a company, as a startup. Your IP strategy has to be always and always aligned with your business strategy. But that can only evolve once you start thinking out loud on the innovation aspect of it, once you start thinking loud on the protectability part of it, and once you start thinking about the reproducibility and scalability part of it. And that's how the IP strategy will evolve. Eventually, why we want to do it? Why do we want to, create so much of IP and so much of, patent activity and trademarks and so on and so forth, whatever we discussed? Why do we want to do it? What is the main purpose of protecting your IP?
So that we can limit our competitors and also improve our valuation.
What else? That's correct. What else? To make money. Why are you forming the company? You should be able to not only limit, but you should be also able to license the technologies that you have developed, license the patent that you have developed. Okay. So IP, when I say that it is a monopoly kind of a tool and you should be able to use it for your own, and you should not, it should not allow other people to copy your stuff and all of that. But at the same time, it gives you the right to sell also. It gives you the right to license also. So in a nutshell, it's a tool which helps you in creating a monopoly, strong monopoly around your products and technologies, as well as it gives you a power to negotiate with somebody who is sitting across the table. Right? Any doubts till now?
Just a quick question.
Yes.
How do you differentiate between an IP and a license? I
So
believe
IP,
you have used these two terms separately, right?
Right, yeah. So license can be given only for which there is IP protection.
Okay, so
Something
by
which you
that,
own.
do we mean that if I create a product which is, I mean, which has an IP, so I can sell that product through licensing? I mean, my technology can be sold as a license. If
Yeah,
I'm,
definitely. Why not? Why not? But you need to take a call whether you want to actually sell it or you want to give it a license. So these are two different things again. So just keep in mind, I'll just give you an analogy. I hope it should be clear to you, because this topic is something which is a separate session altogether.
okay,
Selling means that you have a house and you sold it to somebody at a one-time cost. Fair deal?
okay, yeah,
Licensing is something which is you are renting your house. You are getting rent at a fixed, I mean, on a monthly basis. So
right.
similarly, when you license, you get royalties, you get some upfront payments and things like that. Okay, but we can have a separate discussion on that because that's a day's topic, I would say.
No problem, no problem. Thanks a lot, by the
Yeah.
way. Thank you.
Yes. Okay. Any questions till now? All right, let's move ahead. Come to the very important topic, patents. Okay. This is the most discussed, most anticipated, and most debated kind of a topic. So let's clear some doubts. Let's make sure that we are, aligning ourselves. Okay. So it's a property right granted by the government, meaning which you have to disclose everything that you're doing to the government, or else how will they give you the rights, right? And what does it do? It excludes others from making, using, offering for sale, selling the invention, or importing the invention for a limited period of time. Okay. What is that time? 20 years from the date of filing. So, but in order to say that you have a patent or you have filed a patent on a particular technology or a product or a process or a method or a system, you need to first disclose it to the government by way of making an application to the patent office. So there are different patent offices in different cities, mainly in Delhi, Chennai, Kolkata, and Mumbai. Okay, and these are based on the jurisdiction. So if you are belonging to any of the states which are closer to these patent offices, you will have to go and file a patent in that particular patent office. Now, patents are territorial rights, meaning which a patent filed and granted in India will not have the same effect in US and vice versa. So you cannot say that, I have a patent in US and I want to practice it in India. Everybody is free to practice it in India if you don't have a patent in India, right? And this is something which has happened with Uber. Uber earlier thought that we don't have India as a market mapped out on our business model. So they missed out completely on filing patents in India. And that's how which company captured the market in India first, right? It's a negative right, meaning which, as I told you, it excludes others from making, using, offering for sale, selling the invention, or importing the invention. So that's why it is called a negative right, and it's for 20 years, right? So what does it give? It gives you a right where the inventors can assert the rights against infringers from the date of publication. So there is, we will see quickly the steps and processes in the patent prosecution. There is something called as a publication, meaning which the application that you submit eventually is published on the Indian Patent Office website. And from that day onwards, you can say that my patent is granted to me. The application for which I have filed a patent is granted to me because it is in the public domain. Or else how will you make use of the patent that you have filed? Okay. So this is what I was talking about. There are certain patentability criteria. But now going back to the slide where I was talking about innovation and difference between innovation and invention. Invention is defined in the Patent Act as something which is a new process or a product involving an inventive step and also capable of being made or used in the industry. So in a nutshell, it is novelty, utility, and inventive step, meaning which it has to have some non-obvious element in the process, in the product, in the method, in the system, so that you can call it as a inventive step. So it should go above and beyond the normal literature that is available in terms of the patents, as well as some research publications that are talking about the similar stuff. And there are some statutory patentable invention requirements under section 3 and 4 of the Indian Patents Act. We'll just quickly browse through those criterias and then we will go ahead. So first criteria is novelty. So India follows absolute novelty, meaning which it is not disclosed to the public in India or anywhere else in the world. That is something that can be considered as novelty. Everything that does not form a part of prior art. Now, prior art is a concept, meaning which anything and everything which is documented and available in the public domain before you came up with an idea is called as a prior art. Now, there are two things that happen when you do a prior art search, meaning which when we find out patents in this particular domain in which you are working, we not only get to know that what kind of patents are available in the market, but we also kind of extract an intelligence from that prior art data. What are the drawbacks that I can address now in the available patent documents? And then how I can create my own IP on top of that is something which is existing in the public domain. Now, in order to do that, you have to look at the feature or the elements of the invention. Okay. And it should be, generally be available in a single document, meaning which if let's say if I'm wanting to develop a novel process of creating a biofertilizer, which not only the process not only gives me the biofertilizers, but also generates generates some sort of let's say methane. Okay. Now I want to file a patent on this process, which gives me a biofertilizer as well as methane as a byproduct, because I am adding some things into the in the process, and I have optimized certain parameters in the process, which leads to generation of the biofertilizer as well as the methane gas. Now I have to closely look if there is any single document, meaning which a single patent document or a single non-patent, meaning which is a literature or a publication or a research paper. In that single document only, if I can find these many elements of my invention, it is generally understood that it is not a novel invention. And that's the reason why when we advise people, we tell them that if you primarily feels as inventor, primary feel that your invention is novel, the first thing that you should do is, without disclosing it to anybody else, you should first go and file a patent application. And that's a provisional application that you should file. Okay. What is the inventive step and how it is industrially applicable can be figured out in the meantime, during the process of the patent application. But then if you don't have an application in place, you don't have the right in the invention. Because what did we study? We studied that the rights are only accrued when you file something as a patent or a copyright or a trademark or an industrial design. Now, if that single prior art is there, it defeats the novelty. Okay, which means that your invention has some certain sort of limitations. Now, the second criteria is a non-obviousness, which is inventive step. Okay, so it's a feature of the invention which involves technical improvements as compared to the existing knowledge, or having economic significance, or both. Okay, so technical improvement or inventive step or non-obviousness is not only limited to technical advancements, it is also has to be read hand in hand with the economic significance. So let's say the process that I was talking about, which generates methane and a biofertilizer, it is reducing the cost of production by multifolds. It is giving me the byproducts in less amount of time, meaning which it ultimately adds to my profits, so that I can cater to a large number of customers in a very short period of time. So if your invention involves technical improvement as well as it has got economic significance, your invention is moving towards inventive step. It is moving towards non-obviousness. Okay. Till this point, it is clear. Now remains the last criteria, which is an industrial application. So inventions, simply put, which are capable of being made or used in an industry. So from our point of view, every invention is has an industrial application. Okay, but the problem lies with identification of the novelty and inventive step. That's where we have to sit with an inventor, understand the invention from him in something called as an invention disclosure meeting. So we sit across with the inventor, understand what exactly the problem that they are solving, how unique is the solution, and how technologically improved they feel is the invention. And the moment you as an inventor, as I said, are primarily convinced that this is novel and has some industrial application and it is technologically improved, that is the moment you should file for a provisional application. And I am telling this to you because we get asked this a lot. Like, what is the time that when we should file a patent application? This is the time. Okay. And there is no right time, mind you. With the advent of the technology, you never know, somebody is commonly, parallelly, is working on the same stuff that you're also working on. So there is always a chance that, somebody will file earlier because India follows first to file system. Please make a note of it. First to file gets the patent grant first. And that's the reason why if you are working on something which is novel, inventive, and has got utility, make sure that you're filing the patent and not publishing it or disclosing it to anybody else for that fact. Okay. So as I was talking, there are certain exceptions. So a perpetual machine is something which is not patentable as per the Indian Patent Act. It is not an invention, not patentable, but it is not an invention. Similarly, invention, the primary use of it would be contrary to public order or morality, which causes serious prejudice to animal or human health or plant health, are not patentable. So poker machine, not patentable. If you are discovering something, let's say a scientific principle, or you dived deep down in the ocean and then found out a rare metal which is lying below the sea surface, that you cannot claim and you cannot file a patent on that material. Or an abstract theory, any discovery of living or non-living substance which is already occurring in nature, not patentable. Mere discovery of a new form of a known substance which does not result in enhancement of the known efficacy of that substance, or mere discovery of a new property or new use for a known substance or a process, machine or apparatus, not patentable. Okay. So if you're finding out that I can, probably find out a new use of a neem apart from hair application and dental application or wound healing application, I have found out something else. I cannot claim that. Okay. So there was a famous case of Novartis, for which the patent was rejected by the Indian Patent Office based solely on this particular section. I'm just going to highlight some of the very important ones. Mere aggregation, substance obtained by mere admixture, not patentable. So sugar plus color additive to form a beverage, not patentable. If you are devising a process of making that particular beverage, or if you have, if you have improvised the process to its optimized parameters and you have a very kind of a full-fledged automated process, so on and so forth, with controlled measures and controlled parameters, then probably you can look at filing a patent application on the process. Arrangement and rearrangement or duplication of known devices, not patentable. Okay, so the pencil with a rubber, that's an innovation. That's not an invention. Okay. Similarly, you might have seen umbrellas with torch. Imagine all sorts of those products which are there. So there is some umbrella that I saw which had a USB connector also, which has a small battery. You can charge the phone while you are walking. Right. So these are all innovations. These are not inventions, because every component in that invention is doing its own function. Umbrella is protecting you from rain or sun. and the battery is doing its own job. There is no literal connection between these two elements. Okay. Method of agriculture and horticulture, not patentable. Any process for medicinal, surgical, curative, prophylactic, or any other process of treatment of human beings or animals, rendering them free of any disease or increasing their economic value or of their products, not patentable. So if let's say a surgeon protects a surgery method, let's say removal of cancer tumor, and files a patent on it, what will happen? He will only have the right on the performing of the surgery. He will not allow anybody to do it, meaning which it is going to hamper the overall healthcare ecosystem. The rate of mortality will be higher. Plants and animal as a whole or part, any part of that plant or animal or other than microorganisms, including seeds, varieties and species and essential biological processes for production or propagation of plants and animals, that is not patentable. But what you can claim here is something called as a plant variety. So if you are creating a new variety of a plant, okay, you can still file a there is a process, there is a protocol and a protection protocol which talks about plant protection and farmers' rights. So you can approach that protection. Mathematical or a business method or a computer program per se, only solely algorithms cannot be filed a patent application for. It has to be in combination with the hardware. Only softwares not patentable in India. And of course, copyrightable subject matters is literary, dramatic, artistic, musical works. So all of this presentation of information is not patentable. And some inventions which are related to traditional knowledge. So there is a separate database called as traditional knowledge digital library. So we have to be staying away from all of those things and replicating it in our invention. And if you are doing it, then it falls into the traditional knowledge domain, and which kills the novelty of your invention. And naturally, the inventions relating to atomic energy are not patentable. So these are patentability exceptions. I told you about why do we want to file a patent is, or even in general IP is to enable, is to restrict the competition. It's an investor magnet, so investors are closely looking at what kind of patents and IP that you have secured so that their money is made sure. It gives you upper hand at technology transactions. It gives you a differentiator, technology differentiator. It gives you an identity to the owner of the patent as well as the inventors in the patent. And naturally, because you have filed it and it's out there in the public domain, it provides a platform for the further development. So as I told you, a prior art serves two purposes. One, it tells you whether you should be able to do something like this or file a patent on something which is similar, or it will give you a guidelines as to, oh, this is there. There are certain problems in this product or in this patent which you can overcome. So you build over and above what is available in the public domain. So this is something, a patent application, granted patent application looks like. I'll not go into these details because it will take a lot of time. I just wanted to walk you through the procedure of the patent. Yeah. So from day 0 till the grant of the patent, it takes somewhere around 1.5 years time. And there are these many, the blue blocks that you see are the typical blocks in which the patent prosecution happens. So as I told you, provisional specification filing has to happen once you have, as inventors, you have come to a conclusion that yes, indeed, it is novel and technically improved. Within 12 months of time, you have to file a complete specification along with the claims in the patent specification. The publication of the patent application happens after 18 months of the filing of the provisional patent application. This can be expedited and you can file for early publication also. Then within 48 months of time, you have to file for something called as request for examination. Unless that is filed, your examination patent application will not be examined, and patent office will if you say so, patent office will give you a first examination report for which the reply needs to be drafted and filed as per the suggestions by the patent office. Then there happens a hearing. After that, there is a written submission based on the recommendations in the hearing by the examiner and upon the discussions with the examiner. You have to file something called as a written submission. And after entire of this process, the patent is granted to you and then followed by the maintenance of the patent. So many times people ask us that we want to get the patent granted in less than a year's time. Okay, but a patent grant means that the maintenance costs are going to kick in. So the very prime question that I ask usually is that how are you going to take care of the maintenance fees? Patent filing cost and prosecution costs you have taken care of, but then the maintenance costs is something that you need to really make sure that you are making the payment of the fees at a timely interval, or else all this effort and hustle is going to go in vain. Okay, so the ideal thing is that once you file a patent application, you should immediately start working on the commercialization of that particular technology or the product for which you have filed a patent application. And platforms like these, which CIRCOT Raftar is making available, are essentially for that very purpose. So my humble request to all of you is that I hope you have understood everything which relates to IP in general, patents in details, the process flows and timelines, and what you need to do as the first step in order to protect the businesses that you are trying to build. I hope you have a good hang of all the things that are there. Any questions? I think I've jumped out of our time limit, but then just wanted to wrap
Sir,
up with a message that if you're working on something which is very unique, novel, has got technical improvements, do not wait, do not publish, do not disclose it anywhere else. File a patent application and immediately then you can start talking with your collaboration partners and look forward to commercializing the IP that you have protected.
sir, how can we increase the time or speed up this process as a startup? How can
So
we
you get,
speed the
as a
process
startup,
flow?
you can. So as a startup, Government of India has made some provisions in the Act which allows you to file for, as I told you, file for early publication and expedited examination. Okay. So you can avail those provisions. For startups, the government filing fees are considerably reduced. So you can make, avail those services, avail those provisions also. And that way you can compress the timeline. And in that case, as I told you, expediting means that you will get a grant of the patent very quickly, right?
Okay.
And the maintenance costs come along with it. So we have to take a calculated kind of an approach. You should not just be running behind a quick grant of the patent. You have to also make sure that you have enough cash flows so that your maintenance costs will be taken care of.
Okay, sir.
Ashutosh sir, I have a
Thank you.
question.
Yes, please, sir.
We have developed some food products
Okay.
which are unique, but they are possible only because we have also modified the process of making these food products.
Okay.
So we have applied for the provisional patent of the process.
Right.
Now, in the previous mentoring session at CIRCOT, I was told that we should apply for a product patent.
Okay.
So can we apply for a product by process kind of a patent?
You should. The only caveat there is what you can look into is the
Yes.
kind of product that you're making. Okay. Is it compared to the available products that are out there? Is it giving you, in a layman's term, surprising effects?
Yes.
It may be
is
anything.
giving.
So it may be anything. It could be the efficacy of the product. It could be the physical characteristics of the product. The
Physical
consistency
characteristics,
of.
taste, and nutrition. Three things are better.
Perfect then. So you should ideally go for the product patent as well. or
So I'll
product
come
by
to you for
process.
consultation regarding that, sir.
100% would be very much obliged and happy to
Thank you very much. Thank you.
provide assistance. Yeah, thanks a lot.
So
Thank you.
request you to kindly provide us the contact number.
Yeah, I think you will be given. I think Uday will give it to you, or else I'll just go.
So I have a question.
Yeah, please go ahead.
There is a patent which I have received a final grant regarding tractor mounted sugarcane harvesting machine.
Okay.
So as you told us that we can stop people from importing some same kind of machinery, okay, from other countries.
Yeah.
No doubt those machineries which are supposed to be imported by other people or competitors, though those will be higher in cost in comparison to the one which I have manufactured or for the patent the patent I have received. Okay. So that could that be done by using my patent certificate or the rights which I have? Means can we stop other people from importing the same kind of machinery? I just wanted to know.
Yeah, in the territory of India, yes.
Right, sir. And if some other person has applied for design registration of same kind of machinery, okay. So how can we compete with the people who are trying to get the design registration of same kind of machine? If the patent of the same has been granted for me.
Absolutely wonderful question. So if your patent application has disclosed the design, and they are trying to file something which is very much similar to what you have disclosed in the patent and for which you have got the grant of the patent, you should immediately take actions to stop them from getting the registration of the design, as well as take a corrective actions, legal actions to stop them from manufacturing it also.
Yeah, what if they have got the design registration?
Even in that case, there is a window for which you can file a post-grant opposition for the design. You can revoke the registration of the designs also.
Okay. Is there any possibility for their sustainability if they have made 5 to 10% of change? Means if they have attached something.
So if the design is changed, see, a small, very small design in the in the design is a separate eligible for a separate design.
Okay.
So we have to see what functionality is getting changed.
Okay.
When you have your own design and then what they have as a design. So we have to see the doctrine of equivalence there. There is something called as doctrine of equivalence. We have to check whether the design changes that they have made is substantially improving the functionality of the product or no.
Okay.
If it is not, then we have a case. If it is there, then we have to rethink about our options.
Understood, sir. So for that, I would like to get your consultation and can see your contact number. We will just get back to you.
Yes, sure.
Thanks a lot, sir. Thank you very much.
Hello.
Thank you. Thanks a lot. Hello.
Ashutosh, sir.
Yes. May I know
I have
your
one
name?
question.
I can see Breathing Roots official. Yeah.
So I have a question. Like in earlier slide, you showed that patentability exceptions. In that, there is you gave one example of essential biological process like photosynthesis.
Right.
Okay. So similarly, we are working on pollinations, to which is a service we offer to many farmlands and ecotourism conducting projects. So similar way, can we take a patent on pollination process, to which is improving pollination?
Okay. Two things that you will have to tell to me. One, is it engineered pollination? Can you call it as engineered pollination?
No.
Or
No.
kind of a framed pollination
No.
in a different sense? Is it inducing what do you call it as? When you do pollination, do you see any difference in the growth rate of the flowers, or some technical difference has to be there? Either it has to show
Like
that
it helps to, so it should be helping for fruiting of the plant, like that.
So have you seen a drastic change in the fruiting of the plant?
Yes, yes. If you increase the population of pollinators, then definitely it helps the crop to get good yield.
Okay. And when you say pollinator, is it a device that you are
No,
developing?
it's not a device. We are basically into landscaping. So we plant certain plants which attracts more pollinators, which are
I
pollinator
see.
friendly plants and native
Okay.
plants. So
Okay.
similarly,
Okay.
that concept we are working on.
This needs to be given a little thought as to how do we identify the IPable subject matter here. Of course, there is scope for filing IP, but then on what aspect is something that we need to discuss separately. Because I need to
Okay.
understand the entire process, and only then I will be able to comment on
Okay.
what
Yeah.
can be filed as a patent.
Yeah.
Sure, sir. Thank you.
Thanks a lot,
Yeah.
sir.
Thanks a lot. Thank you.
Yeah.
Thank you. Any more questions? In any ways, I've shared my coordinates with you.
Yes.
Sir, I have a little question.
Sure.
In my
Just
innovative
name
process,
yourself.
myself, Dr. Sainath Kasar, representing
Huh.
Avenir Biolumina Private Limited.
Okay.
So
Okay.
we have developed a product and process which
Huh.
we are presenting in our startup. So in that, the microorganisms are there, but actually we are using microbial extract, means metabolite, not a microorganism in the process. Means in the process, we are just extracting the metabolites and using in the biofunctional units in our.
Okay.
So we have to just in the last session, Harimalla sir said you have to take permission from Chandigarh about the using of microbe, but we are not using microbe, we are using their extracts. So how can we solve this question?
Are the microbes the essential part of your invention?
Yes, yes, yes. These are the microbes converting that substrate into active metabolites.
In that case, you will have to, because anything that involves a biological material comprising of ranging from any microbe or a soil or any plant, leaf of a plant, root of a plant, you have to take permission. Specifically when it comes to microbial organisms or microorganisms, even if you're making a culture, you have to deposit that culture at IMTech Chandigarh, or even in Pune, you have got NCCS.
NCIM.
Yeah, NCCS. They have a separate branch wherein they deposit the cultures. So, and that's a mandate by the Patent Act as well.
If
But
we have, means one of our patent attorney, means patent officer said that we show that the microorganism is purchased from MTCC or NCIM. We will show the bill, and with the use of that microbes, we can show. Is it okay?
see, unless you are having some like commercially procuring it, and if that microbe is not in the repository, you have to deposit it. But then the kind of approach you just recommended, you need to cross-check it first with the patent office officials as well as the people at MTCC.
Okay.
Yeah. Only then, go ahead with this kind of approach. My suggestion would be that you deposit it first. There is no harm in depositing. There is a nominal fees. Bypassing that would not really,
Means
a costly affair.
already the culture is with NCIM. We have brought that culture from
Their
NCIM.
culture is with NCIM.
NCL Microbial Collection Center.
Okay.
Pune.
No, even in that case, sir, I think once it is a part of the patent application, and if you're explicitly mentioning that isolation of those secondary metabolites from the organisms, which inherently I feel is the part of the invention itself. Because if those
Okay.
microorganisms are not there, you will not get the secondary metabolites.
Definitely.
So you need to, I think you need to file for deposition. Should not be a very
Okay.
costly affair. So you should just do it. It is
Okay, sir.
required by the law.
Okay. Okay. Absolutely. Thank you so much, sir. तुमचं लेक्चर खूप
Thank
छान
you.
होतं. Thank you.
Thank you.
Definitely, sir. I'm going to conduct this session because we are running out of the time. We are almost half an hour ahead the time. So,
Right,
Ashutosh sir,
right.
it was a very nice, informative session within all the intellectual property types as well as for the procedure. So, it was very informative to all our startups. As per my knowledge, there are almost out of 20 startups, there are almost 10, 25, 12 plus startups having the patents and they are about to file or something like that. So I will definitely share your
Perfect.
contact on our startup group and they will
Yes.
definitely come to you and talk to you about whatever their startup patent related things. So all the startups, thank you so much for your timing. Next time be attentive for the timing. We are only conducting 5 to 6 sessions. For that purpose, just request to you guys to attend the particular session at a time. So Ashutosh sir, thank you so much for getting some valuable time for us and mentoring to our startups towards intellectual property. We will definitely get in touch with you. Thank you so much.
Thanks a lot.
Thank you so
Thanks.
much,
It
sir.
was wonderful
you.
interacting
Thank you,
with all
sir.
of you. Thanks. Thank you.
Thank you,
Bye.
sir. Thank you.
Thank you, sir.